Hey civic students, I hope you're doing well over our isolation quarantine break from school. And I'm coming at you live pre-recorded from the Drake Gallery of Fine Art. Let me give you the tour. You'll see behind me all the wonderful pictures. There we go. Congratulations, you've had the official tour. So today we're going to talk about sources and types of American law. This week we're starting new content. So this is getting us started on the judicial branch, the third branch of government. We've studied the legislative branch and the executive branch and how they work together to make law. This week we're going to start talking about how the judicial branch works to make law. Interpret law. I hope you caught that. And so what we're going to talk about first of all this week is where our laws come from in America and the types of law that we have in the United States. At the end of this video, you're going to have a chance to demonstrate your knowledge by going to Quizlet and practicing your knowledge of terms and concepts that you're going to learn from this video on Quizlet. You'll have to join, so I'll give you some directions at the end of the video. So let's talk about laws. What are laws? So we know that the three branches of government can make, enforce, and interpret them, but let's talk about actually what they are by definition. So by definition, a law, or laws, are a system of rules that a country uses to regulate the actions of its members or control them. And of course, they're going to have to be able to enforce them through penalties or punishments. So where does this authority come from exactly? Hopefully you guys remember the social contract theory that was first developed by who? I'll wait. Yes, that's it, John Locke. Very good. That's where citizens are going to give consent to the government to make laws for them, to rule over them. And that's going to provide safety and an orderly environment. In exchange, the contract, the citizens will agree to follow those laws that the government makes for them, and that the citizens vote in those politicians that are going to make the laws, but it requires a certain limit to their freedom. Now, what's the difference between authority and power? Because there is a distinct difference. Authority is where you have the legal and formal right to give orders and commands, but power is more like a personal trait. Authority is a formal right that vests in the hands of a high official or personal or management personnel. So really you're looking at authority is our government, and that is the definition of government, ruling authority, where power is going to be something that a person kind of possesses. For example, looking at leadership. You've got authority that comes from a leader, but that leader can also have power. Just because they have power doesn't automatically mean they have authority. The major source of power is knowledge and expertise. In other words, really wisdom. And finally, let's talk about the bottom, rule of law. That's where the laws apply to everyone equally. That's one of our 6 constitutional principles, and that's incredibly important in our American system of government, that the laws apply to everyone, and it applies to them equally, so that everyone not only is treated equally, but also the laws apply to them equally. So no one, therefore, is above the law. So let's now talk about our sources of law, the historical origins of American law, and where those come from. The first is pretty interesting. It's the Code of Hammurabi. If you have studied at all in world history, you've studied the Code of Hammurabi with the Babylonian government. It's the first known system of laws that are written and recorded with punishments, and that's about 1760 BC. They were really harsh. In Latin, we call that lex talionis. We're going to learn a lot of Latin terms in the judicial branch, and this is one that you can be familiar with. You don't have to necessarily remember it, but lex talionis is the eye for an eye. And let's take a look at the next slide for some examples. So on this slide, you can take a look, and pretty much, I like my meme right up here, where Oprah is giving everybody the death penalty, because really that's what's happening in the Code of Hammurabi. Really, there are a lot of laws that if you break them, the punishment is going to be the death penalty. So if you take a look at the second bullet, there are 282 edicts or laws that are written in the if-then form. If you do this, then that's going to happen to you. And you can take a look and read through some of these. Please do take a moment to read over some of these, and even the middle bullet there, the examples from the Avalon Project. Those are really interesting just to skim through. I put numbers 2 and 3 right here at the bottom. So for number 2, if you bring an accusation against a man, then the accused is going to go to the river and jump in. If he sinks in the river, then the person who is accused will take his house. But if the river proves that the accused is not guilty, in other words, he doesn't drown, then he escapes unhurt, and then the accuser is going to be put to death. And then the person who jumped in the river, who was accused, gets to take the other guy's house. So that's kind of what is going on with the Code of Hammurabi. A lot of that attempting to put people to death and using nature to do that. So you might think, why is the Code of Hammurabi even on here? How is this a historical origin for American law? Well, it's putting together that if-then consequence. So here's the law. The law says X. And if you violate the law of X, then Y will happen to you. Of course, or it could be X, Y, or Z may happen to you, depending on the severity of the crime. And with Hammurabi, it also was divided up into socioeconomic classes. Now, looking at the Ten Commandments, this is based on the Hebrew nation. And so this is not only about morality and religion, but it's also about the law. And so we're looking about the time period of maybe around the 1300s BC. One of the reasons we consider this one of our historical origins is because of the Judeo-Christian values of our settlers. And of course, the American settlers that came here, to the New World are going to bring those ideas of Christianity and put those into the law. For example, thou shalt not kill. Granted, that is not just Judeo-Christian. Most societies have laws against homicide. But in particular, we also look at basing our beliefs on God, and you can read those about that in our founding documents. With Roman law, you're looking at 450 BC and beyond. And this is the establishment of the Roman Empire. And this is where, you still have drastic laws and punishments like the Code of Hammurabi, but they also have new laws. And these new laws are going to have commentaries by judges. And that's going to help to establish, of course, the idea on our next slide about common law, which England has, and that we use in America. Now, the issue is here with Roman law. How is it one of our historical origins? The Roman Empire expands into Europe, Africa, and Asia, and actually becomes a historical foundation for many countries and empires of the time. Then at the bottom you have Justinian's Code. You're looking at 533 AD. This, of course, is at the close of the Roman Empire, when the Roman Empire is going to split into the east and western portions. Is just too big to manage. The eastern portion becomes the Byzantine Empire. And Emperor Justinian is going to, in the Byzantine Empire, reorganize all of these massive collections of Roman laws that have, of course, just spread out across the region. And it becomes a part of the law of the Roman Catholic Church, or what we call canon law. So there you can see again how religion and law are tied together. Now, a lot of students may say, well, with historical origins, with religion and law tied together, what about our modern day ideas of separation of church and state? And that's a valid question. Of course, we can't totally separate it out completely because, of course, people can't separate themselves from religion all the time. What it does is this whole idea of separation of church and state says that the government cannot favor a specific religion, which is in what amendment? I'll wait. Oh yes, good. Amendment 1 with the Establishment Clause, if you remember that, where even though we can have our religious beliefs, the government cannot favor, including making laws that favor one religion over another. So those religious ideas and beliefs, including Pastafarians, have to be treated equitably. And the last two ideas for historical origins are the Napoleonic Code and, of course, English law. The Napoleonic Code, in the early 1800s, Emperor Napoleon Bonaparte of France is going to, of course, conquer pretty much most of Europe, and he's going to update Justinian's Code. And it's going to apply to all known territories that France is going to own, including Louisiana, if you remember from your history, the Louisiana Purchase. And actually, some laws in Louisiana are still based on the Napoleonic Code. If you're interested in how, because it does deal a lot with civil law, you could take a look at the article that I have there, and it's got some pretty fascinating things if you're interested in the judicial system. Now let's look last at English law. Arguably, it is the most important source of our American law, and there are two main types or ideas of English law that come into play with American law. Number one is statutory law. Statutory law or statutes just means written laws, like for England, Acts of Parliament. For us, statutory laws are laws that are made by Congress, that are made by the North Carolina General Assembly, which is state, which are made by our county commissioners, which are ordinances, any laws made by a legislative branch. Common law, however, is a little different, sometimes a little hard to understand, but actually just understand this. These are laws that are based on court decisions and not actual legislation passed by a Congress or a legislative body. What happens is that a judge will make a decision. A judge will look at how a law is applied and then will make his or her decision. And they try to use the same kinds of ideas to interpret the law. And so that sets precedent. Precedent means try to be consistent in applying the law. Pre meaning before as the prefix of the word precedent. So you look at what's happened before in order to make your ruling. That is supposed to provide consistency in the law. So if Jane breaks a law, whoever Jane may be, if Jane breaks a law, the law will be applied to her and interpreted the same as if Joe breaks a law, whoever Joe may be. So people are going to be treated equitably, like rule of law. And here, just a really quick look at what has been in our textbook with the development of legal systems. This is a little chart that you can just take a quick look at where you have the development of the Code of Hammurabi in the BC time period all the way up to the Napoleonic Code and beyond for a more modern laws. So now that we've taken a look at sources or origins of law, let's take a look at different types of law. The first main type is constitutional. Of course, we have the U.S. Constitution. That is the supreme law of the land. That is the supremacy part of the Constitution. Do you happen to remember what article out of the 7 articles in the Constitution is the supremacy clause? I'll wait. That's right, it's Article 6. I hope you said 6. If you didn't, back it up, play it again, and say Article 6 so you can get it right. So the supremacy clause is going to say that this federal law, this Constitution, which is a law, Constitution is a law, is our main law, the supreme law of the land. So any kind of constitutional law obviously is going to deal with constitutional issues. And also it's about limiting the power of the government over the people. And so you'll see some examples there on your screen, such as free speech or property rights. It also deals with federalism. Another type is administrative law. And we kind of talked about that with the executive branch. Anytime you say administer or execute, carry out, enforce, or regulate, those 5 terms specifically mean you're dealing with the executive branch. With administrative law, these are rules or regulations that the executive branch must make to enforce the laws. So an example could be the Environmental Protection Agency enforcing pollution laws. And so what they might have to do is they might have to take a law from Congress and kind of add to it, adjust, or provide more detailed regulations in order to accurately enforce that law. Then the third one, you have statutory law. We just covered what statutory law means. Do you remember? I hope so, because it's there on your screen. It means written law. Now, statutory laws are federal, state, or local government laws. And these are things that will govern your everyday life. Speed limits, driver's license, the ability to return merchandise to a store. These are laws or codes that govern our daily lives on a variety of levels, again, local, state, or federal. And then we have international law. That's pretty simple. That's agreement between countries. An example could be a treaty, like the Treaty of Versailles or the Treaty of Paris after the American Revolution. So those are some examples of types of law. Let's keep going. So we have 2 other types of law, and this is where students find things getting pretty interesting: criminal law and civil law. So I want you to be very aware of the differences between criminal and civil law. Criminal law punishes people that commit crimes. If you break a law, that's going to be in the criminal justice system. That's federal, state, and or local laws. It's a violation of our social contract theory where we all agree to follow these laws. So if you're not following the laws, then you're violating a societal contract. So if a citizen breaks a law, they're punished. Is it always equal? It's supposed to be, but we'll see, of course, as we go through some of our Supreme Court cases, how that idea has changed throughout history. Now, in criminal law, this is very important that we have due process for the application of criminal law because your natural rights may be taken away. Due process, Amendment 5, if you remember, that you have, that's where you have your 5 fingers. Do you remember? Grand jury indictment, double jeopardy, eminent domain, due process, and the right to remain silent. This is due process, where if your natural rights are going to be taken away, life, liberty, and pursuit of happiness, then you have to go through a very specific system of criminal justice in order to have those rights taken away. What amendments are very important in the criminal justice system? It's Amendments 4, 5, 6, and 8. So you could do a little cheer. 4, 5, 6, 8. Who do we incriminate? Miss Drake. I hope that was helpful. Kind of like, the push and whip. Anyway, for these amendments, Amendment 4 is about property rights with search and seizure. Amendment 5 includes, grand jury indictment, protection from double jeopardy, the right to remain silent, due process. Amendment 6 is your criminal trial protection, such as a right to a lawyer or witnesses. And Amendment 8 prevents cruel and unusual punishment and excessive bail and fines. Taking a look at criminal law deals with the relationships between people. Natural rights here are really not involved or taken away. We don't have punishments as a result of civil law. We have settlements or remedies that resolve the problem. You're not going to jail in a criminal case. Settlements usually involve money to set someone right to whole. So think about Judge Judy. That would be a perfect example of civil law. So let me get out of the way and we'll take a look at some examples of civil and criminal cases. So criminal, you could be going to jail, you could face a fine. That's deprivation of life, liberty, pursuit of happiness, driving over the speed limit. Homicide, which is taking the life of another human being. Larceny, which is stealing, or illegal drug use. Where civil cases are about relationships between people, child custody issues, divorce, or breaking a contract. I found this particular chart right over here from this particular website, but it's Canadian, so I want you to be aware of that. It doesn't mean that it applies to the American system of government, but what I thought was interesting was, for example, looking at our list, if you have criminal fraud, okay? Fraud is the criminal case, so you are deliberately trying to defraud someone of, say, their money, their property, and you know that you're doing it as fraud. The civil counterpart to that, what's something that's similar to that particular issue but would be civil and not criminal, is a breach of contract. So if you make a contract with someone to, say, repair their roof, and you don't do that, and it's not based on a fraudulent activity, that's an example of how a criminal case could actually be a civil case, just if you have a little different circumstance. All right, it's Quizlet time, y'all. I hope that you guys like the Quizlet and you can get into Quizlet. So if you have any trouble with this, let me know. But here's what you need to do. When you go to this particular website, you're going to have to sign up for the Drake Civics 2019-2020 class. There's a class join link right there so you can get in. What I want you to do is to go to this Quizlet, and I'll show it to you in just a second. And I want you to go through the terms and definitions first with the flashcards, and then I want you to click on the test, and I want you to test your knowledge. And if this works correctly, and I hope it does, I'll be able to see, because you've joined our civics class, I'll be able to see that you have been participating in this, so I can give you credit for doing it for quarter 4, whatever that's going to look like. But I need you to do this by Thursday, April the 9th at 3 o'clock. Or our assignment, of course, is going to lock in Canvas and you won't be able to access that. Okay, so if this works right for you guys, here's what you should see for the Quizlet website. You'll see up here in the corner, Drake NYP Civics is the name of our class. Down below, you'll see the class join link, which you should be on right now. And the title is Drake Civics 2019-2020. And then at the very bottom, you'll see the types and sources of law. And then you should be able to click on that. I hope this works. And then you'll see, oh good, you'll see where we have our flashcards. I'd like for you to go through the flashcards where you see a lot of our terms here. You can flip the card over and kind of read through it. So that's kind of like studying first. You can do the other ones if you'd like, maybe to try to match them, or I don't know about gravity. That's kind of a little hard to do with our particular terms. But I definitely want you to click on the test. And when you click on the test, it's going to generate one for you. And you have to go through, of course, and type in the answer. Now, if you go through the screencast that we just did, or the PowerPoint that I put along with that, that's perfectly fine. This is an open note test, but I want you to try it the very best you can without using the notes. And so you'll see that there's going to be some written questions available, some matching questions, and multiple choice questions, and true-false questions. And then you can, of course, check your answers and see how you did. I'd like for you to score somewhere around 80, 90 or above so you can keep trying. I think if this works out right. So good luck with this. Please give me some feedback. Let me know how it's going. Of course, I'll take any other suggestions or ideas, but I hope you guys have a great week.